A very warm welcome to Not Why But How, a policy podcast where big ideas meet real action. Presented to you by Kautilya Society NALSAR Public Policy Group. At Not Why But How, we believe that good ideas are just the beginning. What matters most is making them work. Just sharp, practical conversation on turning policy into action. I am Devika Virkar.
And I am Jigyasa. And we are delighted to host for the second episode of Not Why But How, Professor Nivedita Menon, feminist scholar, author, and professor at Jawaharlal Nehru University, whose work has profoundly shaped conversations on gender, democracy, and post-colonial politics in India. Professor Menon has long critiqued the homogenizing impulses of state power, arguing instead for pluralism and justice rooted in lived realities. In one of her articles, she asks who exactly benefits from national integrity when women are fighting for basic rights within their homes and communities. This tension between abstract ideas and ground level inequities lies at the heart of her opposition to the Uniform Civil Code.
Professor Menon, your critique of the Uniform Civil Code begins at the idea that uniformity is this desirable constitutional ideal, that there is something to be benefited to every person in India from having a law that applies uniformly. And so this sort of commonsensical understanding that's pushed into discourse about how the homogenization is desirable, how one nation, one thinking, one law, are all of these genuinely sort of something that benefits all the stakeholders involved, is uniformity as a constitutional ideal, a desirable aim for everyone in the country.
Thank you so much for having me here, and excuse my voice, I have a bad throat. So yes, first of all, I don't think uniformity is a constitutional value. I don't think uniformity as such can be a constitutional value in a democracy, because the value of democracy lies in heterogeneity, in recognizing difference, and in ensuring that justice involves, and social justice involves, the recognition of difference. So if you look at the very idea of the Uniform Civil Code, it was built around the idea that for national integrity a uniform civil code was necessary. And in the immediate post-independence period, the women's movement, even pre-independence period, the women's movement, which was very much part of the nationalist anti-imperialist struggle, also saw uniformity as a value. So in 1937, the All India Women's Congress demanded a uniform civil code, and that actually, the demand for the uniform civil code went on till the 80s. Continuously, the women's movement asked at various points, because it was assumed that uniformity meant justice. So when the women's movement was using the word uniformity, and when the general discourse, the mainstream discourse of political parties, etc., was using uniformity, actually we were talking about two different things. And we realized that, and when I say we, I mean the women's movement, realized it when the Shabano case is the big landmark, when we understood that what was then the growing Hindu right-wing movement was demanding a uniform civil code using a very different set of principles. So since then, as feminists, we have come to understand that what we are really talking about is gender justice. And in order to bring about gender justice, uniformity is not only necessary, but may be counterproductive, because uniformity assumes a homogeneous society, and we are not a homogeneous society. No society is homogeneous. And I think as legal scholars and as students of law, you're aware that now legal pluralism is seen as a very healthy principle to adopt. So the idea that legal pluralism is problematic and uniformity is not, is I think what one is contesting.
Absolutely. So when a code such as the Uniform Civil Codes imposes a single set of laws for all, as you rightly mentioned, it removes agency also for these communities to choose which system to subscribe to. And for example, then we ask the question, who gets to decide how a tribal woman or somebody from a marginalized community is able to function, and what personal laws do they have the right to, when for centuries they have had their own social fabric that they're existing in. So ma'am, when we look at, how do you see this tension between a centralized uniformity and a pluralistic autonomy that we've recognized here as an ideal that one should look at while we were subscribing for, especially for the gender justice movement, for women and especially for marginalized women?
See, the thing is that just because feminists are suspicious of and in fact don't want uniformity doesn't mean we think that cultural rights of communities is sacrosanct. We don't believe that at all, because communities are extremely, can be and are extremely hierarchical. There are caste and gender inequalities, there are multiple class inequalities, there are ways in which communities constitute themselves claiming long-standing traditions when in fact most tradition is invented in the modern period. Almost all traditions are invented in the modern period, which means that we are not talking about protecting the cultural rights of communities. We refuse that binary. What we are talking about is gender justice. Now, if we say gender justice, we have to first of all recognize that the different communities in India have different histories with state formation, with law. They have different kinds of understandings of what constitutes marriage, what constitutes the rights of women within marriage. For example, the Islamic marriage is a contract. What is called the Hindu marriage is a sacrament. Now, what is the advantage of a contract? A contract implies two parties who arrive at some understanding. Now, because of overriding patriarchy, the two parties tend to be the families of the two young people, not necessarily the young people themselves. But nevertheless, if you will know, if you actually are familiar with the way the communities in this country function, divorce does not have, it's not such a huge stigma within Muslim communities as it is in Hindu communities. And we have PhD scholars who have studied, who have sat, one of my former student, she's an independent scholar now, Maitri Devi. She has actually studied how these family courts function, and it's very interesting to see how divorce is not, it's not that the societies are not patriarchal, but divorce is not such a stigma. Why? Because the idea of the marriage is that of a contract. So so what I'm saying is that communities are patriarchal, so we are not talking about protecting something called cultural rights of communities. Two, we are saying that all these communities have different histories and different ways in which gender justice is to be achieved. And for that, we need to be, if I say we, I'm saying women's movement, but if we're thinking of state and policy, and if we're thinking of a just state, let us be utopian for a moment and think of the possibility of a just state in which is actually interested in bringing about social justice. Such a state should be listening to all the voices within a community, not just the self-appointed patriarchal leaders. So what happened with the Shabano situation was that the then Congress government decided that the people to listen to were the patriarchy, the Muslim patriarchy, not the thousands of women who marched on the street saying don't overturn this judgment. So I think these are two important points to note, that we should be listening to feminist voices and other voices for justice from within communities, not treat communities as closed. Just as we are saying the nation is heterogeneous, so are communities. I think.
Professor, you touched on this when you were talking just now, but the idea that some of these traditions that are sort of the authority you're appealing to when you're sort of saying, okay, maybe we don't want a uniform code, these traditions have colonial coloration, they have the modern patriarchy's imagination of what tradition or culture is. And thus, how do you then separate when you're thinking about policy? How do you separate these understandings that have evolved over different cultural context over history, and the actual sort of constructed self-satisfying agency of the people, of especially the women who are impacted directly by these ideas?
So in that just society and that just state, or a society that actually aims for justice, we would be having continuous debates and arguments in the public domain, where women would be speaking up, where other groups in communities that are Hindu, there would be castes that need to speak up. So we would have a continuous debate, and no sense that we have to complete and close this debate once and for all. So if you look at, for example, the triple talaq ban, that was brought about by a grassroots movement. It's not, we talk about, there's a kind of sense as if it was a gift from the government. But in fact, it was the Bharatiya Muslim Mahila Andolan which actually fought patriarchy from within their community. They have faced a lot of attack, and they face attack from both sides, from the so-called left secular side, which believes that this is not the time. You have now played into the hands of the Hindu, right? And also from their own patriarchies. But they've stood up for their right and they won it. Of course, the next step of criminalizing was additional, and that is part of another agenda. That is not part of a gender justice agenda. But so I would say, when you say how do we listen to and understand, we need to do two things. One is debates, but second is to take scholarship seriously. It's not like everyone knows how everything is. It's just because you're on social media and you say something, you don't become the arbiter of what is right. And we need to remember that there are large bodies of scholarship on Islamic jurisprudence, on jurisprudence in Hindu communities, Christian communities. Look at that work, look at what feminist scholars have said, look at what judicial scholars have said, and let us try and arrive at multiple different sets of principles by which gender justice and social justice can be achieved. See, the thing is, if I can add one more thing here, the idea that uniformity is good is a very old idea. As I said, it goes back a long way, because there is this understanding that one nation, one X is somehow good, and as you said in your introduction, that's not necessarily the case. But codification is seen as a modernizing move, and modernizing in a good sense, in a positive sense. So if you look at the Hindu code bills of the 55 to 56, those 4 acts that were passed, it's always talked about as reform of Hindu laws, which gave women rights. But that is not the case at all. There's enough feminist scholarship to show that what happened there was a codification, not reform. What does codification mean? What does uniform? It means uniformity. What does it mean? There is a norm according to which everything else has to fall in line. What is that norm? That norm is usually in our country, if you look at the Hindu code bills, it is the North Indian Savarna norm. So if you look at that, maybe you have looked at debates around that bill in Parliament, as you know, they're all available online. You should listen to the way people speak. So in those days, the MPs, I'm not sure, I haven't looked at very recent parliamentary debates, but they're not referred to by party. So you have to go by their surnames. And in India, surnames are very, very revealing, right? So you'll have the North Indian upper caste surname MPs saying, for instance, we would never go and live with a married daughter. It is a sin to even drink water from a married woman's home. This was with reference, married daughter's home. This is with reference to property rights for daughters. And then somebody with a Bengali name or somebody with a South Indian name will say, no, that's not the case for us. And the answer will be, then it's not Indian. Then it's not Hindu. This, not Indian, not Hindu. So codification basically took as the baseline the most oppressed group, which is the Brahmin woman,
Right.
and then reformed her situation,
Right.
but then that brought everybody else down to that level. Matrimony was ended. The better position that Jain widows had was ended. So there are multiple ways in which women lost rights, because you're pegging it to the worst case scenario, giving them 3 rights, let's say, and everybody who had 15 rights is being brought down to those 3 rights.
Right.
I mean, I'm just using these numbers arbitrarily, but just to make a point. So that's something to remember. And the other thing to remember is that it is the Hindu code bills which actually establish technically what a Hindu is. And they struggled. You cannot arrive at a legal definition of Hindu in this country. So you know, so as legal students, you know what the definition is. All those who are not Muslim, Christian, Parsi or Jewish are Hindus. And then there are several point 2, point 3, point 4, all of which are intended to gather together everybody who is not Muslim, Christian, Parsi or Sikh into this, not Sikh, Muslim, Christian, Jewish or Parsi into this label called Hinduism. And so you're creating a mythical community with supposedly similar norms which are to be governed by the same laws, but this community does not exist.
Yes.
It is very clear from the definition. So what we have is actually, and in this point I'd like to just possibly end here, that what we have is not a Hindu majority country, but a country of multiple minorities. And so it's very good to build up a democratic culture which recognizes minority rights of all kinds.
I love that you talked about legal pluralism and you talked about not codification not being it's sort of the colonial sort of idea of it is that codification is a modernizing sort of tool, and that's how the white man's burden manifested itself in law in India. And coming from how there are these historical reasons why we know as a country and we know as individual communities that it has not served very well to sort of go on this mission and to sort of make sense of the law only through certain viewpoints. I'll come to sort of the question that I really wanted to ask with relation to codification itself, is how do you then do the kind of positivistic law that India sort of in policy manifests every single parliamentary session, and how do you do it with the help of the scholarship that you talked about? What authority do you appeal to? Because in this case, clearly the Constitution doesn't seem to be the primary authority, because the Constitution with the directive principles and the directive principles talking about the Uniform Civil Code is sort of taking away that, and in one hand saying, okay, you have fundamental rights, but you also have this.
Look, I see the Constitution much more positively today than I did 20 years ago. Because we were all part of a generation which was very critical of the Constitution for not being just enough, for not recognizing the need to control property, monopoly, all kinds of things, right? We were very critical of the Constitution. But what I've realized in the last 10 or 15 years, many of us, is that the Constitution in fact is a kind of open-ended document. And I think it's kind of like a document with one foot in the future. And I think this is the way constitutions of the global south are, which came out of anti-imperialist struggles. Because unlike the constitutions of the 18th century in Europe, which brought to an end a period of internal strife, and so they established a kind of closure that in future we will not reopen these questions. But if you look at our constitutions, whether it's South Africa, India, a lot of constitutions of the global south, it's about a sense that we might reconsider these things in the future. So the way I see the question of community rights, individual rights, vis-a-vis the constitution, is if you look at the fundamental rights, both are protected.
Yes.
Individual rights and community rights, both are fundamental rights. And questions that might need some thinking later are put into the directive principles to be thought of by future generations, which, as you know, the directive principles also include issues around workers' rights.
Yes.
How is that? If you're so concerned about directive principles, let's implement all of them. But you pick and choose that which suits you. And in fact, the most contentious issues, they're still contentious. cow slaughter is still contentious because the worship of the cow is part of one kind of practice. And there's no one community that worships, one overarching Hindu community that worships the cow. There are people who worship the cow. Their interests can be respected, but not by trampling on the rights of others. Similarly, the directive principles, the Uniform Civil Code, is there in the directive principles because the idea is that you should be able to discuss it later, right? And that kind of discussion, and the first part of your question was, you have a parliament, you have certain ways in which laws are passed. There's no reason why that should be the way laws are passed. There can be functioning committees. And the committees can have actual people who know what they're talking about on those committees, not just people whom the politicians appoint, right? So you can have, I think one of the processes, we saw this process, kind of what is that called? A best practice kind of process in operation with the Justice Verma Committee. Okay. Look at the way that committee went about things. It was really astonishing because it was not just, I don't know if you remember it, so I don't even know if you were born then. But the 2012, the gang rape and murder, and then the committee is set up, and the committee literally goes to group after group after group to ask, what do you feel? A lot of that was incorporated. None of that is in the law. Exactly. Not one of the, none of the really key important things of that are in the law. And the law, as we can see, is completely, it's just extremely punitive without any sense of justice, and on the basis of that law, I don't think any rape case has got justice so far. So I think the fact that there are directive principles to be discussed in the future, the fact that there are two kinds of rights even in the fundamental rights, these are all meant to keep these questions open. So they're open, and we should be able to reopen them and debate them at all times. See, the other thing is that if until maybe even 5 years ago, until maybe even 4 years ago, when we talked about this mythical thing called the Uniform Civil Code, we understood that it was meant to take away certain privileges of Muslim men, such as having 4 wives, which Hindu men cannot have, etc. So that was the narrative. But now we know, and we kept saying this is not going to affect only Muslims. And whenever I say we, I'm usually referring to the women's movement, or now I would say the feminist queer movement, because it's no longer just a women's movement. So what we were then saying at that time was that this bringing about uniformity will not be only about Muslims. But we were not very clear what it would be. Well, thank you very much. Now we know what it will be from the Uttarakhand Civil Code. Exactly. So then it's very clear that the uniformity, and what did we say? Dominant norm. Savarna, North Indian norm. So no intercaste marriage, no interreligious marriage, no self-chosen, no relationship, no self-chosen relationship. So using the anti-conversion laws on the one hand and the Uniform Civil Code on the other, it's like a pincer movement to completely control the autonomy of people, especially young people, to love, live with whoever they want. And it's so brazen, it's so shameful that there's a young couple who's challenging this in Uttarakhand, and one of the obiter dicta of the judge, it's not in a judgment yet, but you know how media reports what they say, and the judge said, so they're arguing on grounds of privacy. Yes. And the judge said, you are so brazen, you're brazenly living with each other without marriage, and you are talking about privacy. This is what the judge, this is like a father talking to his daughter. The patriarchal, familial prison that the Uttarakhand Civil Code is establishing is unbelievable. It's unbelievable to imagine that this is how we will be living. And one of the supposed pros so they've been putting out all this information to make people accept it, right? So the cons, some journalists may find some cons, privacy, this, that. But one of the pros that the state itself tells us is that no landlord will be able to refuse you a place to stay on the grounds that you're not married because you would have been registered with us. Is this does this make sense to anybody? That because we will basically force you into, and of course you into a legal situation, which of course they may not even give you that, right? I mean, most probably because you have to declare past relationships, you have to declare all kinds of things, and of course, one of the things that a friend was saying was that maybe queer people should just go and get there, just go in droves and say, we want to register our live-in relationships, because as far as I know, the live-in doesn't say live-in between man and woman.
Right.
It just says live-in. Does the law say live-in man and woman?
Even to my knowledge, the distinction is not.
So maybe just flood them with queer people saying, because this was actually another thing. I mean, that's fun to say, but obviously it's a huge risk for queer people to take. But it was just a fun thing that a queer friend said. But I think I think I'll come back to that. I've lost the point I was going to make.
Sure. So, ma'am, another thing that I was particularly wondering is, now that where we are at a pivotal moment where the conversations about gender inequalities have now, the queer movement has also incorporated itself into this conversation. I am just wondering, how does the feminist queer movement, when they are asking, for instance, about the right of marriage and the institution of marriage in itself, how does the intersection between marriage or the ask for it, religion, then religion that looks at marriage through its various mechanisms, along with codification, look at all these three pillars when they're asking for equality?
The three pillars, meaning?
In the sense being, when they're asking for the right of marriage, and at the same time marriage is something that has religious connotations associated to it, and is inherently patriarchal. In that regard, and even like feminist movement that look at, then even if they are looking at codifying a bill or like looking at personal laws, how do they then seek religion in a situation, and then how does religion come into picture when itself we've looked at it being discriminatory towards them? Should there be complete separation for them? But then again, if we're talking about separation, uniformity perhaps comes into picture.
Well, you know very well that we don't see. This is the thing. You're feeling kind of trapped in the assumption of the inevitability of religion. We have a Special Marriage Act, and these can be civil contracts, right? So in the 90s, when this debate, 90s and early 21st century, when these debates were really live, and the various feminist and queer groups were actually producing different kinds of alternatives. Something like 5 positions came up, some of which have been very successful. We can talk about that if you like. But I want to focus on this point right now, that there was, even at that time, even in the late 90s, early 21st century, there were actually a draft kind of sets of laws that were produced by queer groups about what a queer family could look like, and how and why the state should recognize those kinds of relationships. So it does not have to be tied to religion at all. There is absolutely nothing inevitable about it. As we know, the Special Marriage Act is very stringently policed. So it becomes very difficult to marry under that act, because the idea is to discourage you, and now especially all the more so. But nevertheless, it still exists. So the idea is that when groups that are not permitted marriage, and in this case it's queer people, what are they really demanding? They are in a situation where if you're not married, you have no rights, and the rights include upon each other, in a sense, right? End of life scenario. Who decides when to, as it were, pull the plug, if that is the situation? Can you inherit? If you adopt children, like let's say it's not a couple that will adopt a queer couple that will adopt. It will be one of the people in the couple that will adopt according to the law, right? So there will be children who will have the responsibility of the children, etc. When the relationship breaks up, how will both partners have some kind of equity? So because there is no other way of trying to establish these things, the word marriage is used.
Okay.
But I don't think that queer people are dying to get into the patriarchal institution of marriage. What they want is a set of norms by which they can live their lives normally, deal with the normal things that can happen in any relationship: breakups, violence, children, property. They just want these things to be established. Now, you can do it as friends, I think. Like you can set up, if you can have a living will in which all these things are laid out. It's possible, but it doesn't stop family members from challenging. And family, here I mean biological family, because that's all that's recognized, right? So if your biological family challenges any of this, it's unlikely to stand up in court. Any kind of arrangement you might have arrived at with your partner. So these are the reasons why marriage becomes becomes one way of just living normally. So I don't think marriage
Couple that
yeah. The reason why straight people marry could well be the reason why some queer people want marriage.
Professor Menon, on that note, I think we've had a delightful conversation. Thank you so much for joining us on the podcast.
Thank you.
And it was lovely having you, and we hope to sort of see you again in the
Thank you
future.
so much for having me.
Thank you so much, ma'am, and thank you so much everyone for tuning in at Not Why But How. With this, we ask you to stay on top of everything that you read about, be critical, and keep asking not why but how. Thank you.